Our speaker this evening, I'm not going to lavish a long introduction on him. I know a number of his groupies are in the room. I don't want to feed their frenzy, so I will just describe him very briefly and succinctly. That he spent. I'll let him self-describe, self-identify if he prefers. He spent, as I recall correctly, remarkably a half-century teaching at Amherst College. Is that possible?
That's right.
Professor of jurisprudence, and also founded and has headed the James Wilson Institute for Natural Rights here in Washington, D.C., and is an outspoken and brilliant advocate for religious liberty and for the rights of the unborn, among other very worthy causes. So we're very honored that he's here with us. I know Diane Knippers would fully approve of our selection. And so, Hadley, thank you for joining us.
Thanks, Mark, for that introduction. Those scotch and sodas look very good. I'm speaking, but I told people, I use the George Gogol principle. I know my limit, I just pass out before I get there. Garrett Snedeker and I were at a ceremony with awards for the Horatio Alger Society, and one of the awardees said, I asked my wife, darling, in your wildest dreams, did you ever imagine I'd be receiving an award of this kind? And she said, darling, I don't know quite how to convey this to you, but you're not in my wildest dreams. Well, I may not be, I hope I'm not in yours. It's a pleasure to be here tonight. It's an honor to be here. I'm Diane. I was looking through some back issues of Crisis Magazine when Diane and I were both writing for them. I found a fascinating piece of Diane's, September '94, on a conference done under the World Council of Churches, supported by mainline Protestant denominations and 3 Catholic orders. The conference was called Reimagining. It was time for women to reimagine God. The concerns were offered earnestly under Christian auspices. But Diane spoke the plain truth instantly. She grasped instantly what it's about. She said that what they proposed was a new faith with a neo-pagan immanent God within creation. With that they missed, she said, the most basic truth of the Judeo-Christian tradition, that it was God who first imagined us. And with that, I want to take you back for a moment to that notable poem by Robert Southey about a man explaining to his grandchildren the Battle of Blenheim, fought in the neighborhood, and fought and won by the Duke of Marlborough. The precise reasons for the battle seemed to fade with memory, and the poem ended in this way. And everybody praised the Duke, who this great fight did win. But what good came of it at last? Why, that I cannot tell, said he, but 'twas a famous victory. 'Twas a famous victory. Well, we've just come through a year of the Supreme Court in which our side has been believed to won a string of cases, and by one, I mean the decisions seem to come down at least on the right side. They were protecting religious people who were being set upon, facing serious penalties, crippling fines, loss of their businesses, subjection to public obloquy and humiliation. We are grateful, as I say, to see our friends rescued. But we have grounds to be less cheered when we consider the reason contained or the principles articulated in those decisions. The decisions went the right way, but I don't think they could give a coherent moral account of the wrong they were averting or the rights they were seeking to vindicate. And so we have to wonder just what real protections or assurances they would offer us for the future. The sense of this disparity between the relief of the outcomes and the reasoning that brought them forth seems to be breaking through now by people rather late. And so we find people genuinely profess to be shocked and surprised that the same activists armed with authority in Colorado have come after Jack Phillips, the Massachusetts baker, once more, even after he has won his case at the Supreme Court. But the governing majority of the court never challenged the ground of the law in that case. They never challenged the claim that the laws in Colorado were on unassailable ground when they condemned discrimination on the basis of sexual orientation, when they affirmed the rightness of same-sex marriage, and condemned them as wrongdoers, deserving punishment, those who would deny the rightness of same-sex marriage. If those laws were indeed rightful and justified, Justice Kennedy suffered not a trace of doubt that they would override any religious claim based merely upon belief. Kennedy's concern that the decisive ground for the judgment was that the commissioners in Colorado had been gratuitous in their expressions of contempt for the beliefs and convictions held by Jack Phillips. But of course, if the laws were indeed firmly justified, as would be the case of people who turned others away on the basis of race, then it would have been quite irrelevant if the authorities, in finding guilt, had expressed contempt for people who were willing to draw adverse moral judgments about the goodness and badness of people on the basis of race. And so if the authorities, in enforcing the law, expressed their contempt, say, for racists, well, that might have been overwrought. But that itself could not have made it wrong to enforce a law that rightly barred racial discrimination. No gratuitous remarks by the authorities in Colorado could have made it wrong then to punish Jack Phillips for refusing to accept the rightness of a same-sex wedding if those laws were indeed rightful and justified. But that is how Mr. Justice Kennedy and his colleagues left it. It was a virtual invitation to the activists in Colorado to seek to try it again, this time testing Phillips's refusal to bake a cake to celebrate transgenderism. And there's no ground on which to turn back that prosecution, unless there is a willingness to test the very substance of the legislation, to weigh in a demanding way whether the law is justified in condemning people. In condemning people who have good reason to regard transgenderism as a deep fallacy and fantasy, a fallacy running against the deep objective truth of nature of people born male and female. And yet this is not what conservative jurisprudence does, to test the very substance of the law, testing the evidence and the principled reasoning on which it's based. When it comes to those morally critical issues of marriage and abortion, the line coming from the best conservative judges has been that the Constitution itself says nothing about marriage and abortion, and therefore federal judges have no grounds in which to declare constitutional rights on these matters. And so those cases should simply be returned to the states and to the police. But marriage was not in the Constitution in 1967 when the Supreme Court dealt with those laws that barred marriage across racial lines. That didn't stop the court from dealing with the issue of marriage in those cases. What was needed at the time was an explanation why race was irrelevant to the meaning of marriage. What had been needed now in regard to same-sex marriage was for the conservative judges to draw again on the arguments offered by George, by Emerson, and others, including me, to make the case for marriage as the committed relation under law of one man and one woman, not that it was merely traditional and familiar, but it was traditional and familiar because it was enduringly rightful. And so he said it. For years, a state of affairs which the liberal side argues with moral conviction, wrong conviction, with spurious arguments. But they are moral arguments. And those arguments are not met with substantive moral arguments on the other side. The persistent retreat is the formulas that are designed precisely to avoid any engagement with the moral substance of the issues, lest those arguments license judges to engage in, gasp, moral reasoning. For moral reasoning has been regarded since the end of the 19th century as subversive of the law. Justice Holmes famously offered the hope that every word of moral significance could be purged from the law altogether. And as the scholar James Auger once observed, by the last quarter of the 19th century, the leading jurists had practically turned all responsibility for questions of morality over to the non-lawyers. Moralists were not interested in law, and lawyers were not interested in morality. So as Holmes condensed the matter, moral rights, if there are any, well, those are for the philosopher, not for the lawyer or the judge. And so we find ourselves now politically, juridically, in this situation. We have a liberal party that has never been more detached from religion, and in fact is now quite hostile to religion. It brings forth now administrations to the left with no compunctions about putting Catholic charities out of business if they will not arrange adoptions for same-sex couples, or putting Christian colleges out of business if they will not cover abortions and same-sex couples in their medical plans. On the other side, we have a political party, more pro-life than ever, but hesitant about asserting the role of the political branches in scaling back Roe versus Wade. And apart from abortion, our conservative congressmen I can tell you definitely, our conservative congressmen just no longer feel comfortable about talking in public about issues such as same-sex marriage, and much less inclined to take some simple steps to start countering or scaling back the decision in Obergefell, the decision that installed same-sex marriage. So what we have now is a Republican political class that will be content to leave the most vexing decisions to the courts. This is what Felix Frankfurter warned about years ago. Just let those judges, those politicians in robes make the hard decisions. You'll soon beat forth a political class quite willing to have the reflexes of civil servants do errands for constituents and not vex their voters. The result is that the conservatives in the country have absorbed the notion that salvation can come only through the courts. And so the main effort is in appointing the judges who might overturn Roe or scale it back. And under these conditions, the future of conservatism lies in people who can shape the list of the lawyers eligible to become judges. These happen to be many of my own friends who have absorbed by now the tenets of conservative jurisprudence. Well, as Don Rumsfeld used to say, you go to war, the army you have. And we're compelled to seek our ends in politics now with allies among lawyers and judges who absorb what I think is the disabling side of what passes these days as conservative jurisprudence. That path of conservative jurisprudence has been a steady backing away from dealing with the moral substance of the cases and prided itself for that detachment by disdaining what is called substantive due process, which is to say, the willingness to do more than ask whether the statute was passed, general in its coverage, prospective in its reach, but to ask whether there was something in principle wrong or indefensible in the very substance of the legislation. In the meantime, we've seen an ongoing trend in the courts, begun by liberals, to transform and undermine the very meaning of religion in the course of pretending to ourselves that we've been protecting the religious. That movement has taken what may be a decisive turn this last year in one of those cases we all celebrated, the decision that delivered from prosecution the master baker, Jack Phillips. But the movement has been long prepared by liberals, most notably in the line of cases dealing with conscientious refusal to serve in the military. At the time of the First World War, the Draft Act removed from the obligation to serve objectors who belonged to, quote, any well-recognized religious sect or organization. But of course, that formulation gave the advantage to churches well-established, bodies of theology long accumulated. It conspicuously left out the possibilities of late revelations, bringing forth new religious sects and churches. That problem was sidestepped in 1940 when exemptions were given to those whose refusal to serve sprang from simply religious training and belief. But what was meant by religion and religious belief? As the years and the cases rolled on, religion was gradually purged of its defining substance. First, it was removed from any claims of truth. We saw references to religious belief, and as we acquiesced that move, we fell in with what John Courtney Murray called the libel of religion, reducing religion to simply the claims of belief which would not claim to be true for anyone who did not share those beliefs. The Congress sought to clarify things in the 40s when it explained that religious training and belief referred to individuals' conviction about a supreme being. But over the years, we find people just rejecting the notion that their views depended on anything like a supreme being. They refer to forces at work in the universe. But the statutes ruled out that conviction about a supreme being, and so they said religious conviction is not reducible simply to readings in philosophy or sociology. But by 1970, that was gone also. The court had a couple of litigants who insist they had their position had nothing to do with any religious reflection. And Justice Black thought that was good enough. They had strong beliefs that took the role of religion in their life. And Justice Collins said, well, you're performing a lobotomy of the statute, but I guess that's the most defensible line. You can't give any preference to religion. So what were we left with? An understanding that reduced religion to a set of beliefs without knowable truths. The court was willing to treat on the plane of religion anything that a litigant professed to regard as the serious doctrine governing his life, even if it were composed of cliches drawn from a superficial reading of philosophy or something read on the back of a cereal box. Mm-hmm. We have to understand this long run of cases, evacuating the substance of what we mean by religion, as we have the run-up to that willingness of the Obama administration to start imposing mandates to fund and support contraception and abortion, even on the part of employers with strong religious and moral convictions. In a very narrow vote, the Green family of Hobby Lobby escapes some ruinous penalties as Justice Alito and his colleagues used the Religious Freedom Restoration Act, RFRA. The test was whether the ends of the government could be accomplished in a narrower way without burdening the sincere religious beliefs of this family. I'll return to that matter of sincerity in a while. But at the same time, the meaning of religion remained a matter of beliefs that hinged critically on the sincerity with which they were held. All of this had been woven into the judgment of the courts for years, but with the decision now in the case of the Masterpiece Baker, Justices Alito and Gorsuch have taken the whole scheme one step further. It's a step, I'm afraid, that may prepare the ground for the entire unraveling of the meaning of religion and the protection of religion, even while often in the course of trying to protect the religious. And here I'm really in quite an uneasy position, because if I find myself at odds with the reasoning offered by two good friends, I don't think I've ever been at odds disagreeing with Sam Alito. I think I see what they're trying to do, so I'll try to explain in a moment. But I think they made a mistake. The key passage in their joint separate opinion builds on a critical line in Justice Alito's opinion in the case of Natal versus Tom earlier in the term. In that case, Alito broke from his earlier string of opinions and now attached the principle of relativism quite explicitly to the doctrines of the court on the restriction of speech. The case involved restrictions on derogatory names for trademarks and businesses. And Alito now spoke for the conservative majority in holding that this kind of law offends a bedrock First Amendment principle. Speech may not be banned on the ground that it expresses ideas that offend. Ideas that offend. This shift was simple but unsettling. For the implication now is that offense is entirely subjective. The different words and modes of expression, they offend people for reasons that may be wholly personal or idiosyncratic. What is ruled out here is that something may indeed be expressed or done in an act of speech that may be offensive in principle, that it may inflict harms without justification. It may be the making of threatening phone calls, defaming people with libel, stirring the mob to acts of genocide, burning crosses. But the assumption is that nothing ever done through the instrument of speech may ever be in principle offensive and wrongful. The lines brought back to me personally the scenes from 40 years ago when I was engaged in the argument with the ACLU over the band of Nazis parading in Skokie, Illinois, in a community containing many Jews who'd survived the Holocaust. And Dave Hamlin of the ACLU said, we must be free to hear the Nazis because we must be free to choose the Nazis. And he said, the First Amendment protects all ideas, popular or despised, good or bad, so each of us can make an intelligent choice. In Hamlet's translation, it was a matter of being popular or despised. Popular or despised. To be despised was really to be unpopular. There's no part of his understanding that certain things may be in principle despicable. And now it may be the height or depth of irony that this position of the ACLU seems to be settled in now as the position even of conservatives on the court. The court has been moving in this direction for years, with Justice Alito as the main holdup. But now, for reasons tricky to explain, he apparently felt the need to just fall in with the currents shared with his other colleagues. Then only months later, in the case of Masterpiece Baker, he was joined by Justice Gorsuch in extending the strand of relativism now to the domain of religion. And so they said it this way: just as it is the proudest boast of our free speech jurisprudence that we protect speech that we hate, it must be the proudest boast of our free exercise jurisprudence that we protect religious beliefs that we find offensive. Once again, but now for religion. Is the assumption now that nothing offered under the name of religion, nothing taught in the name of religion, may ever embrace anything that's in principle wrong or despicable? What about Satanism? How could the affirmation of radical evil be consistent with anything that we would consider religion, rightly understood? And yet, as bizarre as it sounds, that is precisely the argument that's been offered to us by people on our own side, that in order to secure religious freedom from the prejudices of the irreligious, or the people hostile to religion, it's necessary that we stop presuming to cast judgments on any religious teaching as legitimate or illegitimate, defensible or indefensible. And that and only that explains why even conservative judges have leaned on the test of sincerity. Now, ladies and gentlemen, I've been involved in this discussion for 30-some years, going back with Father Newhouse. I can tell you that the test of sincerity has ever been grasped as the one crutch we may hold on to precisely because we don't want to make judgments about the claims of religion that may be plausible or implausible, true or false. But as a matter of common sense, grasped by any person who isn't a lawyer, sincerity can never supply the defect of bad reasoning. This is the most obvious example. The 9/11 bombers were evidently powerfully sincere, and no one takes their sincerity to excuse what they have done, let alone provide a justification for what they have done. Our friends in the courts and law schools invoke the test of sincerity precisely for the purpose of avoiding any moral judgment on the substance of what any religion teaches. And yet, what is the test of sincerity other than itself a moral test? I can readily imagine the characters in the Church of the Flying Spaghetti Monster asking, well, why do we have to be sincere? I mean, what's wrong with the Church of Insincerity? Right? Well, to insist on sincerity is nothing less than to make a moral judgment through the back door, to smuggle it in. Now, apart from everything else that's incoherent here, how does all this come plausibly under the heading of originalism? We hear the thing coming out and going in that we favor originalism in the sense of respecting the text of the original Constitution, applying the Constitution as understood by the framers. Okay. But the American Union and the regime began with the Declaration of Independence, with the God, the Creator, who endowed us with unalienable rights. That God was the author of the laws of nature, including the moral laws. There is no understanding of God more bound up with this regime and the American laws than this understanding. The notion of religion, utterly bereft of the grounds of moral judgment, could hardly be reconciled with the God of the Declaration of Independence. It could not be part of any original understanding. The hard truth of the matter is that no one who takes this line of religion fused with moral relativism, no one who takes this line could plausibly claim to be an originalist. I'm wondering why this point has not broken through to some of our other friends. But quite apart from assigning labels, the root of the problem is that this notion of religion, purged of any standards of moral judgment, contains an incoherence that destroys it from within. If we detach the understanding of religion from any moral tests of what counts any longer as legitimate or illegitimate in any moral teaching, then we have removed as well the moral ground for treating religion itself as a good. If there are no truths underlying our judgments of good and bad, then what is the ground on which we claim religion to be a good that should be respected in our public life? Why would we cast more protections about religion with the Religious Freedom Restoration Act? Why would we insist that the government tailor the means to its ends more narrowly when it starts penalizing people for holding to their religious views? Why should religion evoke that kind of concern which we cannot explain the substance of religion or impute any truth to its teaching? And indeed, we've heard that argument now from adversaries of religion. They've asked us why those beliefs should be accorded any higher degree of deference than the other things that people feel passionate about, whether it's a passion for unions or minimum wage or a passion to save the environment. That challenge has been made, and it cannot be answered by a response that seeks to protect religion by denying that it bears any moral teaching or that the religious may not rightly be governed along with everyone else by laws that truly command what is rightful and forbid what is wrongful. Almost no religious group in this country would claim to be exempted from the laws that bar discriminations based on race. And so the new teaching offered by my friends in the court may be tested in a hypothetical of this kind, not far from a real case. Let's suppose that instead of Jack Phillips, we had a baker who's an earnest evangelical in the fundamentalist Bob Jones persuasion. He sincerely believes that there's a ground in Scripture mandating the separation of the races. And so he refuses to make a cake, not for a same-sex couple, but for a couple engaged in an interracial marriage. He would put himself at odds with the laws running back to the Civil Rights Act of 1964. Does anyone here seriously believe that a court containing Neil Gorsuch and Sam Alito would bring this baker under the same ruling that they used to protect the masterpiece baker? And if that doesn't strike us as plausible, we would move to ask, why would these accomplished judges come out with something so deeply untenable, so radically at odds with the understanding of religion and God that was bound up with our founding, and which they cannot be willing to apply to every case that may arise, including litigants holding positions that they regard as deeply indefensible? The best answer that occurs to me is that the justices have come to recognize, often with regret, that they are actors with an inescapable role to play in statecraft. They may have to make some of the same moves and proofs in statecraft that people in the political branches are routinely asked to make. What our friends on the bench may be thinking is that the wave of political intolerance has risen now so high, with the willingness to treat the expression of political differences as hate speech, that they are more likely to secure freedom by drawing a wider line to protect all manner of political speech, all manner of religious conviction, no matter how zany, protect them from all judgments tinged with political animosity. With this sense of things, they may be willing now to protect some aggressive racists and protect even Satanists in religion, if that is the cost of protecting legitimate religion and religious institutions. As Stan Evans used to say, the problem with pragmatism is that it doesn't work. If we declare now in a grand sweeping way of moral judgment, that there are no grounds for discriminating between legitimate and illegitimate religions based on what they teach, no grounds in which to show that religion counts as a good or as a thing better than anything else, once those moral inhibitions are swept away, what is it that holds the party of the left back when it would impose, by law, this new orthodoxy on abortion, same-sex couplings, transgender, impose these new orthodoxies on Christians, hospitals, charities, and schools, and treat the complaints as mere noise, nothing different from the complaints of people who are overridden in other cases when the votes come in? But our friends rightly ask, well, what are you offering in return? Actually, this could be a moment for me to get off the stage. I think this is the Woody outline. I can't leave you something positive. I'll try out 2 negatives. I can offer something. What do you offer in return? Let me return to the case of the Bob Jones Baker as a possible key. I'm rather certain that Justice Gorsuch and Alito would not find in their reasoning the ground for protecting the Bob Jones Baker as they protect Jack Phillips. And the key difference would have to lie in the substance of the reasoning that would underlie the law in either case. We've come to see why it would be deeply incoherent for the law to draw adverse moral inferences about the goodness and worth of people on the basis of race, as though race exerted a deterministic control over the conduct of any person. For every one of us is a member of a race, and if we're all controlled by forces outside ourselves, none of us would be responsible for his own act. Strictly speaking, none of us would ever deserve praise or blame. The wrong here is rooted in the deep logic of moral and legal judgment, as James Wilson and Kant explained. But no compelling principle of that kind could possibly explain why it would be wrong for people to have feelings or reasons that keep them from accepting same-sex marriage, or why it would be wrong for people to think that there are good reasons to recoil from certain sexual orientations, as for example, pedophilia and bestiality. For after all, even the gay activists make discriminations here. There's been a serious debate for a long while as to whether the Man-Boy Love Association may march in the gay rights parade. Well, even if the gay activists concede that certain sexual orientations may be illegitimate, how could we be warranted in a law that in a sweeping way bans all discriminations based on sexual orientation? We've also found that sexual orientations may be seriously unstable. My dear friend Paul McHugh and Johns Hopkins noted in a 10-year study of 79 non-heterosexual women that it was reported that 67% changed their identity at least once within the 10-year span, and 36% changed their identity more than once. In other words, we do not even have a clear definition of the protected class here, the people who are licensed to launch these lawsuits and prosecutions. Well, these are substantive arguments that would come into play. They're the arguments that would challenge the very coherence of those statutes that have been used to punish people who are accused of discriminating on the basis of sexual orientation, because they will not accept same-sex marriage. To challenge the very premises and substance of those laws offers a path different from the morally empty and futile path of argument offered by conservative jurisprudence that nothing in the text or history of the Constitution establishes a right to same-sex marriage. That argument is always open to the counter-argument, well, what's wrong with it after all? Why can't we try it now? To challenge the very coherence of the law is to challenge the justification for these laws that mete out punishment. That is what conservative lawyers and judges might be willing to talk about if they could break away from the talk about tiers of scrutiny, mechanistic tests, which make no contact with the moral substance of the issues before them. My plea to my friends is that there is a need to detach themselves from the notion that something subversive about moral reason is the law in the fantasy of Justice Holmes could ever be detached from moral reason about the things that are right or wrong, good or bad, just or unjust. Aquinas said that the divine law we know through revelation, but the natural law we know through that reasoning that's accessible to human beings as human beings. And so the natural law of abortion has never been an appeal to faith. That position is dependent on the findings of embryology, woven with principled moral reasoning. There's no ground on which to claim that a child in the womb is anything less human than anyone else walking around. Bishop Laurie in Baltimore got it quite right there. When he challenged the provisions of Obamacare on abortion, he did not argue for an exemption for Catholics from that law. He said it was a wrongful law and it should be enforced on no one. My larger point is that our religion does not come into our public life merely as a claim to be exempted from a law accepted as valid for others, and exempted from that law solely on the strength of beliefs strongly held. The Jewish and Christian tradition bears in our public life in a far deeper way. That was okay. I said the Jewish and Christian tradition bears on our law in a far deeper way from those claims to exception. They bear it by showing why that biped who conjugates verbs happens to be a bearer of rights. Lincoln caught this sense of the matter when he said, "Nothing stamped with the divine image and likeness was sent into this world to be trodden on and imbruted and degraded, or be treated as a being of no standing and no account." The point was also brought home to me in the scene I described in the book of mine, when I had a commission to do a piece on the Holocaust Museum. And as I was moving through the museum, I took a turn and encountered something probably encountered by people here, a vast vat filled with shoes. The shoes of the victims, as the Nazis sought things they could sell or use again. And curiously, what came flashing back to me that moment were those searing lines of Justice McClain when he was leaning in dissent in the Dred Scott case. And he said, "You may think that black man is chattel, but he's a creature made in the impress of his maker. He's amenable to the laws of God and man, and he is destined to an endless existence. He has a soul that will not decompose when his material existence comes to an end." And I said, you get a whole glimpse of the whole situation when we realize that the Nazis looked on this scene and they thought the shoes were the durables.
Yeah.
Right? I had colleagues at Amherst who readily took Nietzsche's line that God is dead and so are the standards for casting moral judgments. They were people of large sympathies, yet even they had to concede they could not give the same account of the wrongness of slavery or the wrongness of genocide that someone like McClain was in a position to give. My pitch to you then is there is nothing morally diminished when we defend the rights of the religious by invoking the same principles that come into play in other instances when we defend the rights of human persons not to be enslaved, not to have their lives taken without justification, not to have their earnings confiscated, their liberties restricted without justification. For these principles are drawn from the same moral core, and to begin with a recognition of the human person as a bearer of rights. Leo XIII caught this point in the opening sentence of his encyclical on human liberty. He said, "Liberty, the highest of natural endowments, was the portion only of intellectual or rational creatures, moral agents. It confers on man this dignity, that he's a bearer of rights. We don't impute liberty to cows and horses, creatures without reason. They cannot direct their liberty to ends rightful or wrongful. They cannot plausibly claim rights of property or put property in the service of a rational purpose." Remember, Chesterton said once, "Animals have no moral religious sense." When's the last time you heard of a cow getting up grass on Fridays? It's only because of how we are seen through the lens of our religious teaching as moral agents, that we are seen as rights-bearing persons, and the full range of our rights come then into sight. Those rights and freedoms may engage things rather prosaic. They may involve the right of a woman to braid hair, or the right of a man on Connecticut Avenue to shine shoes. They may not take a large role ever on the public stage, but they involve the right of ordinary people to make a living, a legitimate calling. There is nothing trivial about these rights, because there is nothing trivial about the human persons who bear them. And so we protect the right of Mr. Green in Hobby Lobby not to be compelled to support a policy on contraception taken as an obligation of the government the Baptista be supported at his own private expense, we are defending him in rights that are bound up with his dignity in the same moral core as his rights of religious freedom. There is nothing diminished about this mode of protecting and defending Mr. Green. The natural law comes into play in a demanding way. We test the justifications that are offered for restricting the freedom of people, whether in freedoms grand or small. And as we defend the religious by engaging these same principles of natural law, what we're not doing is pleading for, I can't bring us enough, what we are not doing here is pleading for a tolerance of their beliefs. The defense of religious people, like Mr. Green, in his right not to have his property confiscated, would be grounded now in principles that stand as objectively true and rightful, even for people who do not share his religious beliefs. And the law is also placed on a ground that can be readily understood by ordinary people, even those unburdened with a degree of law. One of the last decisions decided by the court this term will provide my last example. This was the case on coerced speech and pro-life counseling settings. Some of you may recall the clinic was forced to put up posters with large fonts advertising the availability of abortions for women who may not realize that the state will pay for them. The court, with Justice Thomas writing, struck down these regulations as a species of coerced speech. But as Justice Breyer argued in the dissent, there are many laws on disclosure that compel people to speak a certain kind of content. In the case of Planned Parenthood versus Casey, the court sustained the requirement that the doctors in an abortion clinic tell the women about the nature of the procedure, the risks of abortion against childbirth, the availability of support if they want to avoid the abortion. In other words, people who are generally quite favorable to abortion were compelled to speak words to undercut the abortion. Breyer's dissent was quite pointed. In all strictness, I don't see how Justice Thomas met it. Breyer's argument was predicated on the notion that abortion was simply another medical procedure on the same plane as childbirth. That assumption has been absorbed now for more than 40 years by the defenders of abortion. As Justice John Newman once said, well, stripped of the moral differences, childbirth and abortion are simply two different approaches to pregnancy. They stripped of its moral differences and no difference between a furnace and arson. Breyer didn't see why it was justified in imposing obligations on the providers of abortion to speak words that allows their convictions, but to protect those pro-lifers for the same kind of requirements. But that is exactly where the argument had to be joined. And Justice Thomas did not meet it, and we could have. The court had long recognized that it would be legitimate for the law to register a value judgment, that awful term, a value judgment, recognize the value of human life, even while the right to abortion is still reigning in the law. But might not have it been possible for Justice Thomas to pick up that thread at something more and as simple as this: that the government may favor childbirth over abortion because it is the most obvious difference between the taking of an innocent life and the protection of that life. That we're not dealing with two medical procedures on the same moral plane. Or to put it even more simply in language old and grounded in common sense, that death cannot stand as a rival good to that of life. John Finnis used to make this point in very simple ways. He'd say, we look both ways before we step off the curb going to the street. We have drives to raise food for people suffering famine. And we assume that a crew setting off in an ambulance has the object of getting there to save the victim, not to dispatch him earlier for the sake of avoiding hard choices for his family. The teacher is told to get her students out of the building on that third floor during a fire. She throws them out the window. But we expected her to know. When we said get them out of the building, we meant, of course, we should get them out of the way that preserves their lives. Do we really need to state that? Or do we assume that everybody knows that? Could we fall back then on that part of the natural law, grounded in the common sense that well precedes theory, a common sense so firmly woven into our practical judgment that we may hardly even be aware of it any longer? And would we say simply, as of old, that death simply cannot stand as a rival good to life? It wouldn't have required much of an exertion to weave those simple lines into the opinion of the court. That could have been done even while the conservatives were not threatening now to overrule Roe versus Wade. But what it would have done is preserve a glimmer of recognition that a cohort of judges is well alert to the deep premises that call Roe into question. And if some of them are truly hoping that Roe someday may be overturned, simple moves of this kind could plant in the record some lines that could be drawn upon later to explain why the court is moving to restore the legal protection to life in the womb. And if a justice writing for the court can say such simple things, the lawyers arguing before the court next time will see themselves freer to put those arguments before the judges and invite them to speak them again for the record. There is nothing all that difficult in adding to conservative jurisprudence the common sense of natural law, and it would draw on things so readily understood by ordinary folk that the move may hardly seem unsettling. But the law it would make would take hold at once with the resonance in the common sense and understanding of ordinary people. When we launched this project in natural law 7 years ago, I offered this plea to our friends doing conservative jurisprudence. I asked, why should we settle in with a mode of reasoning about the law that gives us a kind of sing-song morality with terms such as activism, which explain nothing and have no moral content? Some think that the effort to address the moral questions at the heart of the law too ambitious, too risky, too difficult to do well, and likely to license mischief. Our friends seek safety in contriving formulas of the positive law, while cautioning us again not to ask the questions that run beneath the surface to the core of things. Well, ladies and gentlemen, I submit to you, in that path, there has been no safety, and therefore no prudence. And beyond that, no coherence. For we cannot give our best reasons, our fullest reasons, the reasons that give the most coherent account of the decisions we are making, the law we are shaping. And the question for us at the end is, why should we settle for anything so diminished when measured against the moral seriousness of those questions brought before us? Why would we rather strengthen conservative jurisprudence by drawing again on the understanding of that first generation of lawyers on natural right, a teaching that will always be with us, there to be read and learned anew? And where could we find a better assurance that the law we're preserving would be as comprehensible and compelling, as resonant with common sense in the next generation as it is in our own, and as it will ever be? Thanks very much. Thank you. I tried the patience of this audience. Yes, some questions?
Questions or
Sure,
comments?
sure. Here.
Yes. As someone who deals with these issues in other countries' settings, including Western Europe, I often find that debates that come here start there in some ways, or at least appear here in a different form. And as you know, in Europe, when it comes to hate speech, when it comes to certain prohibitions on religious activity, one in the case of France, which I know very well, prohibitions on religious expression in schools, various European countries that are prohibiting the Muslim veil, there's a strange, real value judgment occurring that they're trying to hide. And so, for example, in Germany, they make a determination of what is a real religion and what is a cult. So Scientology is a cult, and hence they try to suppress it. Other things are not. If you criticize certain extreme forms of Islamic belief, you are a hate speech violator who will be prosecuted. It's very complicated, but your point, I think, is powerful. And I wonder if you could say anything about the European kind of iteration of the kind of thing you're talking about.
Well, yeah, we think that the burqa, bearing the burqa, things like that, sure. We know in life as lived, there are going to be mistakes in applying any kind of law. And I remember I used to tell my students, I did a course called Political Obligations that gave rise to a book called First Things. And I used to tell people, this course may come with a codicil that everything you could be wrong. But when you say that, you're implying there are standards for judging right and wrong, and that the currency will be the reasons. We can make mistakes, and we can still reason and argue about them. But when we retreat to the notion of relativism, we'll make no judgments at all. That is a path of serious danger. Remember when we were doing the Defense of Marriage Act back in 1996? And so if we have this, why wouldn't polygamy follow? And the young man from Idaho said, well, people are not much interested in polygamy back home. Well, the reason they're not interested is that the law has banned it for years, right? Now, if you're taking the side now that the law has nothing to say about radical evil, that as far as we're concerned, radical evil is as plausible, legitimate choice as anything yet, would you be surprised if we get more of it? That the adherents will be drawn to it. So I can see us. I can look if they think it's happening in Europe and say, well, I always want to make. As I've argued, I don't retreat to the old judgment about the old Chaplinsky case about regulating speech. There's a certain class of words that have the function of defaming and assaulting, and they can be banned without banning the substance of the argument. So Mr. Roosevelt, getting up in New Jersey, has one adjective, mother F. And by asking Roosevelt, stop using that word, you're not interfering with his freedom to make his substantive argument. Well, Chief Justice Berger once offered an example of a couple having sex on the steps of City Hall, perhaps trying to offer a metaphor of the relation of the administration to the city. And you can see, we could restrain them from doing that without interfering in any way with their freedom to make the most substantive critique of the city. I said, look, you can restrain the white supremacist march while being free to publish Mein Kampf. So I say the most defensible line of that is to try to mark off those words and expressions. Burning of crosses. You know the difference between a burning cross and a burning shoebox. We could do that while at the same time leaving the widest freedom of serious discussion. So again, what I see there is I see some judgment over there that are curious and wrong, like climate change deniers, things like that. I see these mistakes. Once again, I'd say at least the argument is open to us to offer the countervailing argument. Are you sure you really have to do that? Are you sure you have to do that? Are you sure you can't let the Muslim have that beard? Are you sure we really can't do that? It is open to continuing engagement. I'm sorry, that's a long question. Long answer to Chris' question. In the back.
Yeah, I'll try to speak up. Tyler O'Neill with PJ Media. It seems to me that you're arguing that conservatives have marginalized themselves, or at least the arguments applied by the Supreme Court on behalf of those who we would call conservatives have marginalized us. Would you say that the approach that evangelicals seem to have taken in 2016 of choosing Donald Trump as as kind of a secular cudgel to pushback against the resurgent left is another surrender to this idea that conservatives now are a persecuted minority. Believers are a persecuted minority. And we have to defend ourselves by resorting to a pagan who will defend us as a persecuted.
A good pagan.
Exactly. As opposed to actually advocating for what we do.
I see them as reflecting. I see them as reflecting the desperation of the political. We've never seen a Liberal Party this hostile to religion. The same people who are willing to strip doctors and nurses of any protections from being made complicit in abortion. They have absolutely imposing these policies of little. They see obviously no limits, and probably will see the removal of tax exemptions quite clearly. Just the insistence. We saw this back in the 80s, a pressure on Christian schools to fund abortions in their medical plans. And that put a number of small schools under pressure and some to close. I see that happening very easily. If we have an administration of the left, that would have happened. I have no doubt about it. And the courts would be filled now, the lower courts would be filled now, with denizens of the academic left in the law schools quite ready to impose the most fashionable theories of the day on gender. So I think my own reason, Donald Trump was never my first candidate. I used to take a line of Trump that the old Dean Martin roast about Don Rickles. He said, well, some people say that Don Rickles is lewd and vulgar and obscene, but anyone who knows Don knows in his private life, knows it's just the reverse. First he's lewd, then he's obscene. and he was not my favorite candidate, and my friends would say he's challenging political correctness. I don't see that. I don't see him challenging same-sex marriage. I don't see him challenging those doctrines that prevail right now in the American campuses, and that he doesn't do that. He just seems to stand for contempt for the establishment. It doesn't translate that. It doesn't speak in sentences that carry arguments. But I get its foot in you. They saw what was on offer in the landscape, and they thought, this is the only one probably with guts enough to stand for something, and they took a chance. And I look, I have dear friends in the White House staff and people selecting those judges. And I must say, I couldn't imagine it being done any better. So they worked it. Is that Graham over there?
Yeah.
Graham, my goodness. I haven't seen you since you were a little boy. My God. Yes, Jack, you have a question? Oh, did you have a question? Yeah.
Oh, well, I do have a question, of course.
Okay, next one.
Do you want to pose it?
No, sure.
Graham Walker with the Independent Institute in San Francisco. I wonder whether you would accept a distinction between the reasoning that might be appropriate for judges at the state level under state constitutions versus those at the federal level under the U.S. Constitution with respect to the role of substantive moral reasoning, as you have expressed it. Maybe it's related to my deeper question is, if we allow the kind of moral reasoning that you propose at the highest level of constitutional jurisprudence or decision-making, how would that not in principle leave open the door to pretty much the elimination of the text of the Constitution except for maybe the word do or just, thus enabling massive exercise of judicial power in a way that you wouldn't really want?
We see those arguments, forgive me, but they all seem to be predicated on the notion that if we engage in moral reasoning, the other side will engage in it, and we'll be clever. We'll cut them off at the pass. We'll forego it altogether and see if we don't shame them. But our sense is that the moral reasoning has been invoked spuriously to defend indefensible things. The response to that is to show why those arguments are wrong and specious. Not to say that we're going to solve the problem by avoiding moral reasoning altogether, and I don't see how we could do it. After all, the founders would always trace their judgments back to those anchoring axioms that would be there even if they were no constitution. The two things cannot not be at the same time. We don't hold people blameworthy. First principle of moral judgment for James Wilson and for Kant. Doesn't make sense to cast moral judgments on people. for acts they were powerless to effect. We don't hold people blameworthy or responsible for acts they were powerless to effect. There are no circumstances in which that proposition will fail to be true. There may be maddeningly variable differences in whether was Jones really in control, was he really born at the time? There'll be many variables, but the one thing that will never vary is the principle itself. If that principle is true of necessity, as the founders thought they were, they'll be just as true in Jersey City and Atlanta as they are in Washington. So the quick pitch is simply to cultivate anew the things that judges once knew how to do in this country by going back to those, what Hamilton said, those first principles, as he put it, those in disquisitions of every kind, there's certain primary truths on which all subsequent reasonings depend. These contain an internal evidence which, antecedent to all reflection or combination, command the assent of the mind. Of this nature are those maxims of geometry: two lines cannot encompass a space, two things equal to a third are equal to one another, and of like nature those maxims of ethics and politics. You cannot have an effect without a cause. The means must be proportioned to the end. There ought to be no limitation placed on a power destined to effect a purpose, which itself incapable of limitation. He struck that off as a prelude to the Federalist 31. There was a time when judges and lawyers did that kind of thing. And what we're trying to do in Wilson Center is saying we're simply trying to restore the furnishings of mind of the people who did it that way. And it hasn't disappeared. They're still there to be read. Okay, there's another question. Thank you for that, Graham. Yes.
I was wondering, just as an example, I think property rights are an area of law that are under assault. Things like civil forfeiture, where you have property confiscated without a trial or conviction. And I wonder if in like the Baker case, do you think people run to the First Amendment because it's the only bastion left, in the sense that they can't defend on property rights grounds, so they say I'm going to defend on religious grounds?
Yeah, by the way, what I say about this, I'm joined in this persuasion by my friend Mike McConnell, who has argued many cases before the court, and he thinks the line similar to mine. This is a confiscation of assets on the part of Mr. Green in Hobby Lobby. And why not recognize it as it could be it's a taking of property. It's a transfer of assets from person A to person B. It used to be understood that it's just a confiscation of assets. Sure, we can win on that ground. And it's cut from the same cloth as these deep principles that would argue for the protection of religious liberty. So, right, I would certainly invoke those arguments, sure. And again, I see nothing diminished. And it's all in contrast. Look at Mr. Green found himself saying, I believe that life starts at conception. He believes it. It's in all the textbooks of embryology and obstetric gynecology. It's not a matter of belief. It's an objective, anchoring truth. And so what you get here is that our people who cast the argument in terms of seeking a belief in an exemption of the statute by invoking beliefs they don't claim to be true for anyone else. I'm saying, look what we're doing to ourselves as we look for the low door under the wall in some obvious way of winning the case. Okay. Yes?
Is there a microphone coming?
No.
Oh.
That's what I heard.
A while back, I can be loud, I suppose. You mentioned, I believe it was a Skokie case in '78.
Yes, I was in the middle of that one.
Yeah, well, actually, I think that was when the ACLU stood what they originally stood for free speech, because everybody has to remember that popular speech doesn't need protect. The First Amendment is for unpopular speech. And people need to look up who was behind that march. That's a little interesting story. I don't, and then you also mentioned something about like legitimate religions or something religions. What did you say, pagans or something?
Legitimate and illegitimate teachings.
Well, who defines that? I mean, is the government going to define that?
Let's say I invoke you cannot be or not be at the same time, or people ought not be held responsible for acts they were powerless to effect. Would you respond by saying, who decided that? At a certain point, if there are truths there, they stand on their own, and we can just to invoke, say, who's to say that, is to back again into the assumption that everything before us is subjective. It depends on the
And then the whole
idiosyncrasies
idea
of
that
people.
everything has to be under religion. Because I know a guy who was an atheist, and I mentioned that. I brought this up at a certain conservative think tank, that he was an atheist, and he could not have grounds, because he's not a religion, because he was against gay marriage.
Because he was against what?
He was against gay marriage.
And therefore what?
Because he was not a religion, he was an atheist, but he was against it. But he couldn't have grounds on religious bearing.
Well, right. Can he have merely a moral ground?
Well, that was a very point. That is a very point of natural law reasoning. Look, my own experience in teaching, the one example of natural law reasoning, which one heard is most readily grasped, is that abstract that Lincoln wrote for himself. Imagine himself engaged in an argument with a owner of slaves, saying, "Why are you just making say the black man that he is less intelligent than you? I'll beware. The next white man who comes along more intelligent than you may rightly enslave you. It's because he is darker than you are. Beware again. The next white man with a complexion lighter than yours may enslave you." The upshot is there's nothing in principle you could cite to disqualify the black man that would not apply to many whites as well. And we simply drew on the same mode of reasoning in regard to abortion. Why is that offspring in the womb anything less than human? Doesn't speak yet, neither do deaf mutes. Doesn't have arms and legs. Other people lose arms and legs in the course of their lives without losing anything necessary for their standing as human beings to receive the protection of the law. This is an argument that is accessible to people across the religious divide. Catholics, Baptists, atheists. You don't need a college education to understand it. That was precisely what was meant. The teaching of the church's teaching on this, the Catholic Church, has never been an appeal to faith. It's always been that natural law reasoning. So it's not at all remarkable that this man can work his way to an argument without depending on religion.
This also gets back to you were talking about, like, there's the whole idea of freedom of association.
Right?
Freedom of association. Like if somebody, like the free market can reign, and if somebody wants to be racist, which I would find abhorrent, and I think most people would, but you might do it with something else. So why do you have the government come in there? You know?
All the great exponents of a free economy, Edmund Burke, Adam Smith, assumed that the law would have to be in place to do what only the law could do, to mark off the boundaries of what is legitimate and illegitimate commerce. Whether prostitution and pornography would be available to be demanded and supplied would depend on the judgment that the community could make through the laws about the things that are decent to offer a people. So it is never every time we talk about free association, we see free association in legitimate things to a legitimate end. And as you know, John Quincy Adams said that freedom to associate and to petition the government, that would be there even if it weren't in the First Amendment. It would be there even if there were no First Amendment. It would be there even if there were no Constitution. So what I'm offering you is a matter of deliberating again in that mode, the way those people used to deliberate. They drew the Constitution from principles that were there before the Constitution. The Constitution is not the source of their own understanding about law. And at times we can't complete this project of law unless we cultivate, and as an earlier generation did, the art of returning to those ancient truths. One more question. Oh, this gentleman over here was trying to get something in the floor. Okay, yes.
I've been practicing law since 1971, and I've watched the laws of morality. From my perspective, theologians have been replaced by the social sciences, psychology,
Right.
sociology, and anthropology, and they provide a scientific, neutral, amoral foundation for human conduct. Therefore, sin disappears. The other thing that's that's concerned me so much is that individual responsibility has been supplemented by social justice. Social justice makes society responsible for sin and not us. Do you have any comments on that?
How many days do you have? Of course, it's implicit in social science that we look for things like the root causes. And as soon as you start looking for the root causes, poverty and so on, you assume that poverty is determining the morality. And of course, you saw the court get into a bad situation like that in Brown versus Board, where the embarrassing thing was that the framers who made the 14th Amendment had plenary control of the schools of the District of Columbia, and they never thought that the 14th Amendment enjoined them to desegregate those schools. They couldn't cite the text of the 14th Amendment. They couldn't cite the understanding of the framers. They appealed to social science. But the problem was the social science went in the wrong direction. Because the finding was that it was the students from the children from more integrated settings that are more likely to reject their blackness than the students from the segregated settings. So you can't cite the text, you will not make the moral argument, you can't cite the understanding of the founders, you cite social science, and when the social science points in the direction, you simply invent what the social science is. And at this point, you see the utter collapse of the whole project. Ladies and gentlemen, thank you. I think I've